Can you, is this on? No? Can you hear me? Is it on?
Nope.
No?
Get close on it.
Really close, really close. Oh, I have to be really close. Okay. Can I take it out and just hold it like this? Okay. Fantastic. Well, thank you so much, Representative Wallace and the committee for hosting this. This is really fantastic. Really excited about the potential for this legislation to help more people regain access to being more fully participatory as citizens and being able to rebuild their lives with that participation. End It for Good is a Mississippi-based nonprofit that invites people to support approaches to drugs that prioritize life, preserve families, and promote public safety. And if you're wondering, wait, why are we talking about drugs? This is about voting rights. About a half to a third of people in jail and prison have ongoing substance use disorder. And about a half to a third of all property crimes are committed by people who are trying to get money for drugs. So when we go upstream in the criminal justice system from something like a money charge, we often find addiction in that person's life and the reason why they ended up doing things that are against the law. And so as we think about ways to help people avoid incarceration and a criminal record and the disenfranchisement that might come with that, we want to begin looking at what those root causes are of why people get involved in the criminal justice system in the first place. And very often that is some sort of addiction-related issue that is expressing itself in a way that's really harmful to that person, to the rest of society. I got involved in this movement as a Mississippian, born and raised here. I've lived in the Jackson area my whole life. And I became a foster parent in 2014. And that was my first connection point really to the criminal justice system or addiction at all. I began to see that in the lives of the parents of the children that we were fostering and realized just how many children are in the criminal justice system, either because their parent is struggling with addiction or because their parent is incarcerated or trying to rebuild their life and regain custody after incarceration. And that really propelled me on this journey to want to understand how we can reduce harm and how all of Mississippi has a better opportunity to thrive if we can handle the problems that we have in a way that is more restorative, that really helps all of us by helping more people live productive and engaged lives as citizens. And so over the course of the last couple of years, I started End It for Good, and we have hosted about 40 events around Mississippi, everywhere from South Haven to Pascagoula, Natchez, Meridian, Jackson, Greenwood, Tupelo. We've been all over the place and had about 2,000 people that have come, everybody from state legislators to mayors, judges, everybody in between. And one thing has become so clear to us in that, which is Mississippians want to know what actually works. What will actually help more people be able to live thriving lives? What's going to help them move forward? What's going to help them provide for themselves and their families? What's going to help them have stable families and not fragmented families? And so as we have worked on that issue, particularly from the angle of drugs and addiction, one thing that we have seen is just how many people are impacted, that it's sort of a silent impact to the rest of us who might not feel that. So when we look at how many people have criminal convictions of some kind, it's between 1 in 5, 1 in 4 Mississippi adults have a criminal conviction of some kind on their record, and about an estimated 1 in 10 have a felony. So when you think about what that does to people's ability to find employment, to vote in many cases, and how that impacts their ability to return as a full participating member in the community. So going upstream again, thinking about addiction, what helps people, if we want to keep so many people from committing crimes to get money to support their addiction, doing other things that might be very harmful, how can we help more people recover? What we know now from research is that punishment and trauma do not help people recover from addiction. It actually often makes addiction worse because addiction is often a response to pain and trauma in a person's life, and they are self-medicating that with substance use. And so when we go upstream to look at what could potentially help that, we find that the things that most help people to recover are connection, purpose, relationships, community. And so everything that we can do to help people reconnect to the community, be fully participating citizens, find that purpose and that connection and those relationships in healthy, positive ways, it really helps all of us. It doesn't just help the person who's struggling. All of us, every Mississippian is better off when we have more people who are maybe not addicted in the first place, but certainly in recovery if they have been through addiction. There's a popular saying from author Johann Hari. He says the opposite of addiction is not sobriety. The opposite of addiction is connection. And I think that's a really key piece as we think about the opportunity we have to restore voting rights to more people, to give them the opportunity to reconnect as a citizen, to reconnect and let their voice be heard in a positive way. If we want more people to be able to stay on that path of recovery, to find that instead of to recidivate, we want to help them find that path forward and take that opportunity. When we can remove those barriers to full participation, we have the best chance of everyone benefiting. When I think about what happens after a person comes out, even beyond the restoration of voting rights after a period of time with no other criminal involvement, thinking about something like expungement. We were looking into this recently for other work that we were doing, and came across that Michigan had done a huge automatic expungement program last year. And they estimated that actually 10% of their residents would have convictions automatically expunged. 10% of Michigan residents would be eligible for this, having something taken off their record. And it would leave about 400,000 of their citizens conviction-free. So this was not a situation where they had so many convictions and this would really only be a drop in the bucket. There were lots of people that would have no other conviction on their record by expunging after a long period of time, certain low-level nonviolent convictions. So for a state like Michigan, they decided to make that automatic so that people didn't have to go and pay, a couple $1,000s to an attorney to file the paperwork for that or figure out how to do that on their own. And they're able to remove that barrier to opportunity and participation for hundreds of thousands of Michigan residents by something they did legislatively. And think we have a similar opportunity with so many Mississippians impacted by the criminal justice system. We have a huge opportunity to remove some barriers and allow more of our fellow citizens to be able to fully participate when they have been able to get their lives back on a positive course. And that helps all of us when we're able to do that. So I'd love to introduce Brittany Chancellor. She is a graphic designer and print manager for MagCorps, and she's going to come and share a little bit of her story of direct impact with us. So welcome, Brittany.
Good afternoon. First, I would like to thank Christina Dent from In It for Good and State Representative Price Wallace for giving me this opportunity to come to speak with you all today. If you would have told me 10 years ago I would be coming to the Capitol to speak to state representatives about my voting rights, I would have laughed. The truth is, I've never been interested in politics until now. I grew up in Pearl. I graduated 2004. I've lived in Mississippi my whole life. Come from about 5 generations of Mississippians. My great-grandmother, who raised me, and she was born in the 20s, you can imagine, she was adamant about voting. I can remember her getting up early every election day and voting before she went to work. She would say, every vote counts, even hers. So she always tried to teach me right from wrong, good morals, good values, but I was a stupid kid. I made some really, really bad choices, got involved with drugs, alcohol, ended up in treatment a couple times. And when I was 18, I went to prison for the first time. At that time, there wasn't a whole lot of options in prison to really get it together. You just did your time, got out. So I got out. And I couldn't get a job anywhere. Nobody would hire me at the time. I went back to old behaviors again, went back to prison. Still, there weren't a whole lot of options. I was hard-headed, and I just wasn't ready to get it together. I was just being stupid. So I got out again and I lost my grandmother and I got back on drugs again. Apparently I hadn't hit my head hard enough. So I went back to prison again, but this time they gave me 10 years mandatory for making counterfeit money. Well, this time it was different. My grandmother and my mom had died. I had to do something different. I had to get it together. This time there were options in prison. I got a chance to start teaching classes, be involved in classes. I became peer support certified. And this is when I had a chance to get involved with MagCorp, which is the company I work for now. In case everyone doesn't know about MagCorp, their mission statement reads as follows. Our mission is to create better futures for offenders through job training, work experience, and comprehensive support. That's just what they did for me. I learned skills and began to believe I had something to offer. They encouraged me to know and believe that I was more than what I had ever done. They were helping mold me, really. They were building me up to be a part of my community, this community. A big part of doing that is voting, which I'm not allowed to do right now. When I was in prison, I can remember coming in from work one day and the guards were like, okay, you got to stay in from work tomorrow. There's a lady coming to talk about voting. Honestly, it kind of made me mad because I knew I couldn't vote because of my charges. It was pointless. I knew I would get out one day once I had served my time, but I was never going to be able to vote again, ever. And right now, in this world, like everything that's going on, our beliefs and our values being attacked, I would love to vote. Some of the girls at my job, they always get on to me because they say I'm so political now, but I can't vote, you know? It's just a big deal to me. I have a bumper sticker on my car. It's a big deal to me. Truth is, I know it's important to follow the law. Breaking the law should have consequences, and I paid dearly for those. And I'm so glad that I got out and got my life together. When I got out of prison, MagCorp offered me a full-time job. Today, I'm a graphic designer, print manager for MagCorp. We do all the stationery, signs, anything to do with print for the governor's office, the AG's office, the legislative budget office, the MDA, the DFA, schools and colleges, and many others. I'm a manager now over several incarcerated ladies who I get to help train and mold, just like what was done for me. I'm a full-time salaried state employee with PERS retirement benefits. I'm a notary. The state trusts me. The state trusts me to notarize legal documents such as subpoenas, wills, and trusts. I also get to notarize absentee ballots for incarcerated individuals to vote. I asked one of the ladies if I could use her as an example. One of the girls at my job, she's incarcerated, came in about a month ago and was like, I need you to notarize this document. So I'm like, okay, what is it? She's like, it's my absentee ballot. And it tickled me because I was like, sure, even though I can't vote. Yeah, give it here. So I did. And I'm happy that she does get to vote. And I'm happy that there's others that are incarcerated that do get that chance. So today, my professional life is completely different than before, as well as my personal life. I'm getting married next year to a wonderful man who stands behind me 100%. We're involved in a church that we love in Brandon, Mississippi. I have a German Shepherd and a cat that I adore. So much of my life has been changed, redeemed, and restored. I'm so thankful for MagCorp, who saw me as a person with potential, not just a person with a past. I'm also thankful for the opportunity to share my story today and ask you to consider giving people like me a second chance at participating in one of the most important roles we have as citizens, the ability to vote. Every vote matters, and I hope the legislator will give me an opportunity one day to cast mine. Thank you.
Next, I'd love to, go ahead.
I'll just say, any of the committee members have a question for Brittany? Go ahead, gentleman from DeSoto.
Well, Brittany, first of all, I want to just thank you for coming and talking to us. And I know that's always a little scary, but I'm very proud of the fact that you gotten on the straight and narrow but my question to you is this. How long has it been since you've been clean and out
I've been out since January the 18th of this year.
okay.
Yes,
All right.
sir.
Anybody, any other questions from committee members? Brittany, we're so glad to have you here today, and that's a awesome story you told.
Thank you.
I apologize.
Perfect timing after she finished.
That's a new noise.
I'd also like to welcome Daniel Awamdi, who is the founder of Care Center Ministries, to come and share a little bit. Daniel has been involved in, after his own life was changed, continuing to give back and to help many, many, many more people regain their lives. And so he's going to share a little bit of his own story and a little bit of the work that they do, because what they do is so crucial to the work we all want to see happen, which is more people able to live restored and recovering and productive lives. So welcome, Daniel.
Thank you. Good morning. Good afternoon, I guess. Thank you for allowing me to be here. Thank you, Ms. Dent. Thank you, Representative Wallace. I'm grateful to be here. Just the opportunity to speak. Let me just start with the beginning of my life. So my parents are from the Holy Land. My dad was born in Tiberias and my mom was born in Nazareth. They're Palestinian. My dad moved over here in 1953. When he was born, it was Palestine. It got transitioned from Palestine to Israel in 1948. So his greatest opportunity was to come here. He went to college in Arkansas Tech. He was a chemical engineer, worked for Owens Corning Fiberglass in Oregon. That's where I was born. And at the age of 3, we moved to Mississippi. He retired for Owens Corning Fiberglass. And he always taught me, you have an opportunity here. It's a democracy. We vote. This is a, because he went through a struggle where he grew up. And so he always taught me, to vote. He was very political. He paid attention to it. He always had the news on. But in my life, at the age of 16, I grew up in Madison County. I started using drugs and alcohol. I started with marijuana. At the age of 16, immediately I became bound. I had insecurity in my life just because, I'll just tell it. The majority of the people that I was around was either white or African-American, and I was this Palestinian kid in Madison County. And so I had some deep-rooted insecurity, which led me to use drugs at the age of 16, which led me to be addicted, which turned into a 22-year of addiction and crime. I was arrested 35 times in those 22 years and was in prison 5 different times. When I was in prison, I never thought about voting, but I always understood that I couldn't vote because of the felonies and the convictions that I had. I just thought that was just going to be a part of my life. I'm not going to be able to vote, even though I was interested in voting, even though I was interested in the things that were taking place in our country. But at the end of the 22 years, God opened up a door for me to enter into a nonprofit organization, a faith-based program called Care Center Ministries, and it started in Dallas in the 80s. My pastor had a similar life to me, to addiction and crime. He met the Lord, went to church, got a burden in his heart for the east side of Dallas, and that's how the ministry started. We actually have we're in 5 different states now. And so when I went to this ministry, it was just an opportunity to be discipled. It was an opportunity to walk out a Christian life with Christian principles, biblical principles like faithfulness, submission to authority, a good work ethic. And it wasn't just something that we read, it was something that was implemented through the program. I remember my 2nd month there, we do an hour of worship every morning. And God put a burden on my heart for my hometown, which is Jackson, Mississippi, Central Mississippi, where I became bound to addiction, to drugs and crime. And I immediately started having a big burden for people, broken people, people who were lost, people who were dealing with addiction and crime. And so I went through their internship program, which is a 3-year extension. I got my college associate's degree in international studies and ministry. I was trained to be an inner city missionary. And then February 2nd of 2019, I got sent back home which I thought I'd never come back home. And we launched an extension of the ministry. We're actually been here over 5 years now. We launched a church, Hilltop Church, which is 30 seconds from here. We're at 785 North President Street. Our church, we deal with children, we deal with the youth. We have a food pantry. We serve 150 to 300 families every Wednesday at our church. On West Street, we have a 3-house property, which is our men's program. It's a 1-year faith-based discipleship program, or 3 years if they go into our college program. We have about 25 guys in that program. And then we have a women's program called the Tree of Life, which is near the Eastover neighborhood. We have 20 women in the program there. We've had it for 2 years now. And so God's just allowed me to come back into a place to be reformed. He's given me freedom. He's given me an opportunity. And now that I'm leading Hilltop Church and leading this ministry and teaching people and teaching families the biblical principles, I can't vote. And I wish I could vote. I wish I could, vote against some things that allowed, like the marijuana. I'm just going to put it out there. That's the first thing I did at the age of 16. If I was able to vote, I'd vote against it because it was one of the things that was the gateway for me to be an addict. And then the things that are biblical principles, which, Jesus Christ set me free, those are the things that I would vote for right now. Those, I would lean towards voting towards someone who would hold those biblical principles. So I believe, and I ask that, people who have been convicted and reformed, or people who have been convicted who've done their time, I feel like we should have the same amount of rights as anyone to be able to do those things. And so, yeah.
All right. Excuse me. So anyhow, you say you're back here and got church going and everything, and that's, I'm assuming you pay a city taxes, state taxes, just like everybody else, but you just don't have a voice in the political.
Yes,
In other words, like you said, you don't have an opportunity to cast your vote for a mayor or president or whatever the case may be. And that's something I think is very important for everybody, is to, be able to have that right. Men and women fought and died for that right. So I appreciate you today. As any committee members have a question for Daniel?
I'm sorry I missed some of your testimony. I was getting them to quit using the hammer drill down underneath us. I guess I have the same, and I love the fact that you were pouring the faith into folks, because we know as believers that God is the one power that can cause us to turn our life around for the better. And so thank you for doing that. But I guess the same question I'd have for you is the question I had for Ms. Brittany, and that is, how long has it been since I'm assuming, I didn't catch it, but I'm assuming you served some time and then came out and went into the ministry and are ministering to folks that are in the same boat that you've been in. How long has it been since you've been out of?
It's been 10 years since end of 2015.
Okay.
The gentle lady from Hines.
Thank you. Thank you so much, Mr. Chairman. I meant to ask Brittany this too, but what are you convicted of?
Got a simple robbery charge, bank robbery, possession, uttering forgery, stolen vehicle. I've been arrested 30 something times in the 22 years I was an addict.
Okay.
No violent crimes.
No violent crimes.
No violent crimes.
Okay, thank you.
Any other questions from the members? All right. Well, thank you, sir. Appreciate you coming. Christina, thank you. You have any closing remarks or?
One thing that you just said reminded me, there's another woman who was hoping to be able to come and share her story today, Denise. She lives in Northeast Mississippi. And when she was sharing her story with me, she had another commitment today and couldn't come down for it. But she said, oh, I would have driven however far I needed to come and share this. She said, I own about 50 properties in Mississippi. I pay taxes on all of them. My husband and I have a business. We serve all kinds of other Mississippi businesses with it. And, we're allowed to participate in those ways, and yet I still can't vote, and just felt so passionate about that. So thank you for putting this together and giving people like her, people like Brittany and Daniel on the front end or on the further end of their returning from incarceration, the chance to share and to advocate for some opportunity in the future.
Gentleman from DeSoto has a question for you.
Yeah, thank you, Mr. Chairman. Christina, I heard you say something a minute ago, but I wasn't quite sure I heard it right. You said 1/10 of is it people that have been incarcerated have a felony, or it was 1/10 of something were felony, and
All Mississippi adults.
all Mississippi
Mhm.
adults, 1/10 of them
Yes,
have
that's
a
the
felony?
estimated, if you take a number of numbers and you crunch them down, the estimation is 1 in 10 adults have a felony and 1 in 4 to 1 in 5 adults have a conviction of some kind.
Okay. And of those 1/10 of adults, do we have any idea of how many of them can't vote?
I don't. Those numbers were not part of the number that came up with the 1 in 10 felony, so I'm not sure how many that is.
Okay, thank you.
Thank you. While I'm gonna call Grant Collin with Empire, let him come up. While he's coming up, the Speaker's office done a survey, or a poll and on criminal justice reform. And the numbers come back. This is the question that was asked. Do you support or oppose restoring voting rights to individuals who have completed their sentence in probation, paid all restitution or fines, and have had no additional convictions for 5 years? Support overall was 68.7%. Republican support was 57.7%. Strongest supports 46. Overall, Republican strong supports 29. But oppose overall was 17.8%, and among Republicans, the opposition was 25.1%. So the numbers here shows, I mean, that in general, the majority of the public go along with what we're looking at today. Anyhow, Grant, we thank you for being here with us today, and the mic is yours.
Thank you, Mr. Chairman and members of the committee. We are honored to be here. I'm going to introduce my friend Kayla Hewlett, who's going to share her story, and then I'll have some remarks after that.
Thank you, Grant. I just want to start off by saying it is such an honor to be here today, and I want to just commend the amazing testimonies of change that we've just heard. Continue the good fight, guys. I'm super proud of you. I'm also here to speak from a personal testimony standpoint. The woman that you see before you today is not the woman, or should I say girl, that I was 12 years ago. I was a very broken, lost, afraid little girl, and I was strung out on drugs. I should not be here today. All of the statistics were against me. I had a rough child growing up. At a young age, I didn't realize that my life was so different than those around me. It was difficult, but I just thought that that's the way that it was. Both of my parents were heavy in addiction, and it was a very unhealthy environment. There are always people in and out of our home, and all hours of the night. My parents were very abusive to one another, and we were very poor. I can vividly remember my mother nodding out in the middle of what she was doing and giving me narcotics at a very young age. My dad was also in and out of jail most of my life. Excuse me. Eventually, DHS got involved and I was placed in the care of another family member. As I got older, I would begin to visit my parents on the weekends, and I would begin to use drugs with my mother. By the time I was 16, I was using crystal meth with both of my parents. By the age of 17, I had become a full-blown IV drug user. Up until this point in my life, I had done very well in school. I was a straight A student, a part of the beta club, science team, any club you could think of. I seemed to have a bright future ahead of me. I truly had goals and dreams, and I didn't want to have the same life that my parents did. But I ended up following along in their footsteps. It's the only lifestyle I had ever seen. By the age of 18, I had lost my mother to a drug overdose while my father was currently serving prison time. After my mother's death, my 3-year-old little sister and I were left to figure out life on our own. She went to live with another family member, and my addiction and my life spiraled out of control. I did not know how to cope with the loss of my mother. I felt very angry, abandoned, scared. I desperately needed a support system and a safe place. This was such a dark time in my life. The only way I knew how to grieve was to turn deeper into the drugs that I was using. I wanted a different life, but again, I did not know how to go about getting that. I began to do whatever it took to fuel my addiction, as addicts do. I didn't even recognize the person I had become. I found myself being held hostage by a man that I was using drugs with. When he fell asleep, I found a way out of the home. I took his money, I took his drugs, I took his car, and I took off. And I ended up lost, riding around Oxford, University Avenue, 3 a.m. with my headlights off, and I was pulled over and arrested. I truly believe that God saved my life that night. I was charged with a felony possession charge. It was a controlled substance, felony possession of a controlled substance. I was only 18 years old when I was convicted of that felony. In that moment, I truly felt that I had thrown my life away. I thought, no one will ever want to hire me. What is the point of even going to college? Everyone will always look at me like an addict, a felon. Honestly, I didn't even fully understand the consequences of what becoming a felon meant at that age. All I knew is my dreams of living a successful, different life were crushed. I felt completely hopeless. I truly wanted to have a good life and to do the right things, but I didn't know how. I'd only seen the lifestyle that my parents had growing up, and that was what I had witnessed. And so I did what I knew, you know. It seemed impossible to break free of that cycle of addiction. I wanted to be better, but couldn't seem to find freedom or a way out. I knew, though, if I didn't do something soon, that I was going to end up dead like my mother or in prison like my father. I wanted to get my life together for my little sister. She needed me desperately. I tried short-term treatment centers. I was in and out of treatment multiple times, but I always returned back to the same area, didn't have a support system, and always fell back into my addiction. Even while I was in the local treatment centers, there would be people who were just there doing time. They weren't sincere about getting clean and changing their life. I would even end up getting high with those people when I went home and relapsed. Again, just an endless cycle. I would eventually, excuse me. I want to touch on that if you have nowhere to go and you have no opportunities, and then you go back into the same unhealthy environment, the same unhealthy home like I did, the same town where it's too difficult you go into the same town where it's too difficult to get clean. It does seem impossible. And that's what many Mississippians face. I tried hard for my sister. I wanted to have a different life. I wanted to be strong for her, but my addiction was stronger. I wanted to be better for her, but I didn't know how to do that. I needed a new way of life. I needed purpose. I needed to get away from where I was at and focus on myself and building a relationship with Christ. After failing to uphold that felony probation, I was court ordered to a faith-based program called Saving Grace Women's Home in Brandon, Mississippi. It's formerly known as Teen Challenge. This program led me to a relationship with Jesus Christ, and it also helped me to find a new way of life. It helped me to find a new support system. I got the healing that I needed. I was able to grieve my mother's loss properly. They taught me work ethic and how to just live a successful life drug-free. Although I had found this new hope and purpose, I still faced many obstacles, though, after having that change, particularly the felony that was on my record. I was denied getting an apartment. My license was suspended. I was afraid to try to go to college and get denied a loan. The list goes on and on, right? I wanted to move forward in my life, but I wasn't sure how to do that. It seemed truly like the system was stacked against me. I couldn't understand how someone was expected to get a job with a felony and then to pay the fines and get a car and get their license, all of these things without having that stable, good, solid job. It just seemed like a cycle that wasn't possible. It truly felt impossible. Thankfully, though, the program that I went through allowed me to live there at the women's home and to work for them. I continued to have regular visits with my probation officer, stayed clean. I was able to pay off my fines and complete my felony probation early. But even then, I had to wait the allotted time to be able to try to get an expungement. That entailed me also saving a good bit of money. After paying off all my fines and working to get my license and do those things, I still had to come up with over $1,000 to hire an attorney and to pay for the expungement. That was very challenging. It was truly a struggle. But I knew if I would continue to fight for that and push for that and save for that expungement, that would open many doors for me. Getting that expungement was truly a huge turning point for me because my past wasn't holding me back anymore. It boosted my confidence. It opened those doors for me. I was able to obtain custody of my little sister, attend and graduate college, buy a home, vote, and even carry a gun to protect myself. It felt like the sky was truly the limit and that I could finally achieve the life that I wanted. And I was so thankful to no longer be confined by that consequence and my past. People do change, as we have seen. I'm proof of that today. I am a wife, I am a mom, I am a daughter, I'm a child of God. God healed me. He also healed my dad, who has had, several prison sentences. He's performed many miracles in our lives. My dad ended up going to a similar program, to a Mercy House Teen Challenge, and he has turned his life around and is currently clean and living and doing well. I'll just tell you, it's an amazing thing to see someone go from cooking methamphetamines to raising their hands at the altar at church and being clean. It is a beautiful thing. My sister is now 17. She still currently lives with me, and she never had to go through those hardships that I went through because of the life changes that I was able to make. Over the years, I've had the privilege to continue to serve in the ministry that helped me turn my life around, Saving Grace. I'm able to share with the ladies that I work with that there is hope, and they're facing the same challenges that I did, most of them. I want them to know that expungement can be possible for them, and it's vital for them to be able to rebuild their lives in their journey. Receiving it can reassure them that restoration is possible and that there is hope for their future. I truly believe that people can change. I have witnessed it time and time again. People must have hope, though. They have to have hope. We can't throw people away because they've made mistakes in their past. We don't want them to just accept who they are in the midst of their addiction. They need to know that they can have a future and that there is opportunity ahead of them. When people do turn their lives around and they do start getting it right, the gift of expungement is one of the greatest things that we can give them for them to be able to succeed and progress and move forward with their lives. Second chances are absolutely vital and necessary for those people to recover and succeed. And I just want to thank you all for considering that for those people, for these Mississippians. Thank you.
You got a question, gentleman from DeSoto?
Thank you, Mr. Chairman. Kayla, thank you for coming and talking with us today. And you're the poster child for that. There's nothing impossible with God. And I agree with you. Hope deferred makes the heart sick. There's a verse in the Bible that talks about that. If you rob people of hope and they feel like there is no way to better themselves, it can be the very thing that feeds them back into a negative cycle. But the question I have for you, and just because we're lawmakers don't mean we know all the law. And even if you're an attorney, doesn't necessarily mean that you know criminal law in and out. But the expungement process in Mississippi, can you talk just a little bit about that? You said you had to wait an allotted time. You had felony charges, is that?
Yeah, yes.
And so can you just elaborate a little bit on that? And if you don't have the answer, I imagine Grant probably does.
I can speak from what my experience was, and then if, you want to piggyback. For me, I had been given 5 years felony probation, and I was able to complete that in half of the time by paying my fines early and staying clean. And so I believe it was 5 years after the completion of my sentencing that I was able to apply for an expungement or the process. So I
And
had
the-
to hire an attorney and
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 do you
that-
know if that's the same regardless of like age of conviction?
I'm not sure.
Yeah, I don't know the answer to that either. I think the detail, I mean, the point of our current process is it's a case by case process that has got to go before a judge versus an automatic process when you've served your time, you've waited a certain period of time, and it's a nonviolent offense. But I bet former Representative Bain can answer this when he comes up.
Lady from Hines.
Thank you so much, Mr. Chairman. I'm sure the former chairman will have a lot to say about expungement because we actually tried to fix that and the legislature actually passed the bill and our governor unfortunately vetoed it. But I just wanted to state that I think you said that you were convicted of a drug felony. And this is why this is so important, Mr. Chairman. I really appreciate you for holding this hearing because the disenfranchisement process is so convoluted and confusing that a lot of people think that drug crimes do disenfranchise you, and they don't. And we've been trying through this process to pass legislation that would restore a person's right to vote for nonviolent crimes. And I can appreciate my colleague asking the question about how long it's been since you turned your life around. But the fact of the matter is it shouldn't matter how long it's been since you've turned your life around. Once you've served your time and you've paid your fines and fees, you should be restored, period. As a citizen of this country, it is your birthright to be able to vote. That's why we have a democracy. It puts the power in the people's hands to be able to elect the people that represent us and to create the change. And so I hope, and everything has been great, and I really appreciate you having the courage and the others to have the courage to testify, but I hope that this body will decide that we should restore these individuals despite what they've done. If we believe in the power of Jesus and the love of Christ, we should also redeem these people, redeem you all, so that you can return as full citizens, not as comme ci, comme ça citizens, but that you get to exercise your right to vote. And I just want to thank Chairman Wallace because he's had the leadership to really carry this forward as far as we've gotten, and I hope that we can carry it across the finish line this time. Thank you.
Kayla, I appreciate you coming in. I appreciate sharing your story with us. And I understand you live in Braxton. Okay, that's in, I'm your representative. I don't know if she voted for me or not. I mean, thank you for coming. Grant, thank you for coming. Go ahead.
My pleasure. Let me just start by thanking you for your leadership on this issue, Mr. Chairman. I know this is something many of you have worked on for a long time. I'm optimistic that there's growing momentum to get something done. Let me tell you a little bit about why I care about this issue. So you introduced me. I'm Grant Callen. I'm founder and CEO of Empower Mississippi, an advocacy organization that works on a lot of issues. But this is one we really care about. And some of you know our work on education. But since 2018, we have been involved in working to remove barriers beyond the classroom. So part of what we do is try to identify what is it that's holding somebody back, that's standing in the way. What is the obstacle that's keeping them from flourishing and having a great life in Mississippi? And we want to identify what those obstacles are and work to remove them. And when you start looking at our criminal justice system, there's a lot of obstacles that people face even after they've served their time. One of the things that I've noticed that's so disheartening about this state that I love, and I'm a sixth generation Mississippian with deep roots here, we seem to give up on people far too quickly. When an individual fails, we frequently make the path to becoming rehabilitated, to becoming that productive citizen, we make it really hard. And sometimes we make it nearly impossible. And often within our criminal justice system, punishment for crimes tend to continue long after their prison sentence has ended. So a felony conviction, for example, is something that one often lives with for the rest of their life. And it can make finding work and housing and other important necessities really challenging, if not impossible. Virtually every job application, lease agreement, loan application requires a disclosure of a felony conviction. Nonviolent felony shoplifters, for instance, are forever categorized as a blight on society alongside far more serious offenders like rapists and murderers. And this issue doesn't just impact a handful of Mississippians. According to a recent report that Christina Dent referenced as well, it's estimated there are about 240,000 Mississippians that currently have a felony conviction. So that's 1 in 10 adults in our state with a felony conviction. This impacts individuals, families, communities, and is I think a key driver of some of our workforce participation challenges. We all want safer communities, but what policies actually make us safer? You know, deterring would-be criminals ought to be a top priority for policymakers and law enforcement, and yet deterrence is one of those concepts that's one of the most misunderstood in all of public policy. Conventional wisdom says, if we want to deter people from committing crimes, we should have long, harsh sentences. Prisons should be miserable places, and we should continue to punish these people long after their sentences are over as a cautionary tale to other would-be criminals. And it seemed like common sense. Honestly, I believe this for much of my life, that this is the appropriate and effective approach to criminal justice. Make it really harsh so other people won't want to commit those crimes. And yet, this approach is completely divorced from reality, and it's divorced from the empirical research about what we know works today. So here is a really key principle that applies to a lot of factors in criminal justice. If less crime is the goal, what matters most is, for deterrence, is the certainty of apprehension, not the severity of the sentence. So if criminals know they're going to get caught, and they feel very confident they're going to get caught, they're far greater chance of not committing the crime than simply if you have a long sentence. And this kind of makes sense if you think about it. Most criminals don't know what the punishment is for a crime. They haven't read the state code. They don't know how long they're going to serve. But what's remarkable is this principle, this certainty of apprehension matters a lot more than the severity, is something that criminologists on the left and the right agree on. They overwhelmingly agree that long, harsh sentences and lifelong obstacles, these kinds that we're talking about that extend long after your prison sentence is done, really don't deter criminals. But when people think that they're likely to get caught and punished quickly, that is an important deterrence. Now, to be clear, dangerous people need to be in prison. So we should prioritize law enforcement, officers on the street. We should arrest and convict people as quickly as possible. But long sentences, especially for nonviolent crimes, don't make us safer, and they cost a lot of money. So at Empower, one of our top priorities is public safety, and we believe actions should have consequences. Punishment for crimes should be swift and certain. Otherwise, we risk devolving into lawlessness. And if you want to see lawlessness, go look up videos of Portland and San Francisco last year when they decided not to enforce the law on things like shoplifting. That's the opposite direction that Mississippi should go. However, we also believe in the power of restoration and redemption. And we believe that the punishment should fit the crime. To that end, not every crime deserves a life sentence. And if the obstacles continue for the rest of your life, the effect of your crime is it has become a life sentence. But that's what we do when we take away voter rights, which also takes away the right to run for office at any level, or a Second Amendment right, including self-defense. And when we don't allow a record to be expunged after a period of time, because that hinders employment, it hinders housing, and a whole range of other parts of normal life. All for an action that could have occurred years or even decades ago. So in our opinion, lifelong punishment for a nonviolent crime through the imposition of these barriers really is not in the best interest of anyone. It's not in the best interest of the person and their likelihood of turning their life around. And it's not in the best interest of community members and taxpayers either, because it doesn't keep us safe and it's an incredibly expensive cost. So further, these barriers may actually jeopardize public safety. There have been some recent studies that show voting rights for those with a felony conviction can improve public safety. And I'm quoting from one of these studies. The reentry process after incarceration improves because restoring voting rights gives citizens the sense that their voice can be heard in the political process. And it contributes to building an individual's positive identity as a community member, unquote. We know that the two most important factors to recidivism, not having a job, not having housing, are key drivers, as I said, of recidivism. And if you have a felony conviction, it makes it really hard to solve both of those problems. So recidivism goes up. Finally, our state's workforce is diminished when we make it more challenging for those with a felony conviction to get a job. We have, as you know, the highest incarceration rate in the country, and with so many fellow Mississippians after they serve who have a felony conviction, it's not hard to see that these barriers are among the top reasons Mississippi has fewer people working as a percentage of our citizens of any state in the country. Our workforce participation rate is at 53.9%. Only 53.9% of Mississippians age 16 and up are working. I think a key driver of that is that 1 in 10 people have a felony conviction. The report I referenced earlier also notes that those with a felony conviction face real big challenges to re-enter the workforce. In fact, a criminal record can reduce the likelihood of a callback or a job offer by nearly 50%. And formerly incarcerated people are far more likely to be unemployed. So nationally, if you have a felony conviction, there's a 27% unemployment rate for those with a felony conviction. You compare that to the general population unemployment rate's about 4% right now nationally, and in Mississippi, it's less than 3%, it's 2.7. But if you got that felony conviction, even if it's decades and decades ago, it's going to be a barrier for you to get a job. So it's no wonder that the report suggests that this very issue could be contributing to our state's labor participation issues. Fortunately, this is not a problem without a solution. There are solutions to these things if we have the courage to act on them. So today we've heard from individuals who have been impacted by this issue. You've heard firsthand about how imposing the Second Amendment and voting rights and making people have a felony conviction for the rest of their life, the barriers that creates for them. You've heard real stories about how this issue is impacting the lives of individuals who just want a second chance. And I want to commend this committee for the work you're doing trying to address this. Let me close with this. What you're considering, anytime we talk about something with criminal justice, it's so easy to put it in terms of tough on crime or soft on crime. And I just want to remind you that what we're considering today is not a choice between public safety and lawlessness. It's not a choice between tough on crime and soft on crime. The reforms being discussed today really represent a choice between the status quo, which has contributed to our labor issues and our crime issues and our poverty issues. It's a choice between that status quo and an evidence-based approach that will truly change lives and communities for the better. We're not for defunding the police. We're not for putting hardened criminals back on the street. We're not for abolishing prisons. But what we're encouraging you to consider today is a pathway for offenders who have paid their debt to society to rebuild their lives. We're talking about ways to remove barriers for those who want to go and become productive members of society so that they can successfully reach that goal. We're encouraging you to continue exploring ways to make it more likely that those who have made mistakes in the past do not fall back on old patterns and old habits that led to those crimes in the first place. And I believe that is a laudable and achievable goal that will improve public safety, save taxpayer money, and positively impact our communities all across this state. And I commend you lawmakers for leading on this. Thank you for what you're doing.
Thank you, Grant. Appreciate you coming. Any of the committee members have a question for Grant? Jim DeSoto?
Thank you, Mr. Chairman. Grant, I appreciate your comments. We've got a sheet here that shows disenfranchising crimes. There's 22 of them on here. And I don't know if I should direct this to Nick when he gets up there or to you, but I know that the number one key determining factor of recidivism for people that are out of prison is whether they get a job or not. So that is obviously something that we need to find a solution to. But at the same time, I mean, I'm looking at some of these disenfranchising crimes. Are there, and I don't know who provided this. Was this one of the particular presenters, or is this?
No,
It was just, okay. But I'm looking at some of these here, and it's a catch-22. As somebody that comes out, you want to give them a second chance. You want to make it so that they can find a job and not have to pay for it the rest of their life. But at the same time, as an employer or an organization that's looking to hire somebody, I mean, I need to know if a person has committed statutory rape if I'm going to hire them from my preschool in the church. You know, I need to know if they've been convicted of embezzlement, if I'm going to have them handling money or things where the temptation is there. So where's the fine line between the rights of the employer and the rights of the individual when you come out? I mean, and I don't know if you, I'm just throwing that out there,
Yeah.
but if we can answer that question, I think that most of the headwind towards trying to come up with some type of expungement process has a greater chance of getting there, because there are some things that if I'm an employer, I'm going to want to know if this person has had a history with something, depending on what I'm hiring them for and where I'm looking to put them. And I guess I'll ask Nick, which of these are considered violent? Because I just put a V next to the ones I think would be violent, and it's about half of them on the list. So just throwing that out there.
Yeah, I mean, I can just tell you where we come down. Well, a couple of things. We do not support what is a national proposal called Ban the Box for private business leaders, because that is a mandate that tells private companies, private business leaders what they can and cannot ask. But we do support the ability for there to be a process that takes a nonviolent offense off somebody's record so that they can start fresh. And when we're talking about nonviolent offenses, to me, that's an important distinction. There are certain crimes that you deserve to have that offense linger with you and stay on your record for the rest of your life because they reached a certain threshold of severity. I don't know of any serious effort, certainly not one that we've supported, that would try to push for an automatic expungement on any kind of those violent crimes. The parole reforms that we have worked on over the years specifically excluded things like murder and sex offenses because of those things. So to me, we're talking about our approach is if it's a nonviolent offense, and for us, if there has been a time that has passed. And we supported the bill last year, 1609, that said it had been 5 years after your term, your prison sentence ended. That's enough time to know that they've turned their life around. They're trying to make a new effort. Let's get all of these obstacles we can out of their way, and make a smooth path for them. So it's not perfect, but that's kind of where we come down on that issue.
Any other questions from the committee members? All right. Grant, we appreciate you coming in today, and Kayla, appreciate you coming too and sharing your story with us.
Thank you.
I see we're moving on pretty good on time, so we're going, Camp Murphy and Evan Preston.
Thank you very much, Mr. Chairman, members of the committee. My name is Evan Preston. I'm Director of Advocacy with Secure Democracy USA. And what Camp's handed out now, I just want to explain to you are, one, the slides that'll be up on the screen just for your ease of reviewing those materials. And then we have a couple of handouts that'll go along with those slides, so you can follow along and have that for your reference as well. I want to echo the comments commending the leadership of this committee and the members who have worked so hard on the topic of voting rights restoration and the disenfranchising crimes for several years. It's a privilege to be here today with the previous speakers that are willing to share their personal stories as well. What I'm going to present on is putting in context the current state of the law in Mississippi and the potential pathways that exist from experiences of other states for the policies affecting disenfranchising crimes and restoring rights to people. In our presentation here, you'll see that in all but 2 states and DC, individuals who are convicted of at least some crimes lose their right to vote in the U.S. Whether and how a person becomes eligible to vote, again, varies across states. And in some, the process for restoring eligibility is limited and complex, while in others, it is universal and automatic. In several states, court-ordered fines, fees, and restitution and other financial obligations must be satisfied prior to restoration. But as you'll see here, in 46 states, there is provision for automatic restoration of voting rights for at least some people who have been disenfranchised for crimes. In 23 states, including places like Utah, Montana, and New Hampshire, there is provision for restoration following incarceration for some or all felony convictions. And here in our third slide there, you'll see that we would focus attention on the vast majority of states in which the right to vote is restored automatically upon release, either when a sentence is completed with probation by the sentencing court or upon successful completion of the term of incarceration. In some states, the rights are also restored upon grant of parole by the Board of Pardons. In 15 states, including Texas and Louisiana, there's provision for automatic restoration of voting rights immediately following probation or parole. In the automatic restoration process, an individual's right to register and vote is only suspended for a felony conviction while they're incarcerated on parole or in probation. And once the person's sentence is complete, they automatically have their right to vote restored, and they are permitted, though not automatically, then registered to vote. One example is in Louisiana, in which an individual's right to register to vote is only suspended for a felony conviction while they're incarcerated, on parole, or probation. Once a sentence is complete, they automatically have their right to vote restored, and they may register to vote. Another example is the state of Florida, in which voting rights are restored automatically depending on the type of offense. And generally, a person must complete all the terms of their sentences. The types of examples of this in Florida are a conviction for murder or a sexual offense makes a person ineligible to vote unless and until the person's right is restored by the state clemency board. For any other felony conviction in Florida, a person is eligible to register to vote if the person has completed all the terms of their sentence. Completion of that sentence includes the prison time or jail time, includes the parole and probation, other forms of supervision, and it also includes the payment of the total amount of fines, fees, costs, and restitution ordered as a part of the felony sentence. The other form of restoration of voting rights is through application. And restoration through application, the category of process that Mississippi currently has, is in which, of course, the individual must apply and possibly provide the documentation to a relevant authority to restore their rights. There are 4 states in our country that require application for the restoration of voting rights: Mississippi, Alabama, Tennessee, and Virginia. And in Mississippi, the people convicted of disenfranchising crimes may regain their right to vote by pardon by the governor or a 2/3 vote of the legislature, as has been noted by members already. People convicted of 1 or more felony barred from voting, and this applies, as has been noted, to many nonviolent crimes. To regain the right to vote requires this extensive process in the state of Mississippi. And as a result, over the last 27 years, only 207 people, to our knowledge, have successfully regained the right to vote through the current suffrage process. Generally, this has involved about 18 bills per year that were introduced and 7 to 8 people who were successfully restored their right to vote through that process. Another state with restoration through application, Alabama, has the felony disenfranchisement structure that perhaps most closely resembles Mississippi because certain felonies lead to disenfranchisement. The Alabama Constitution states that no person convicted of a crime of moral turpitude may register or vote. The legislature has codified the list of felonies that lead to disenfranchisement in Alabama. And in Alabama, in just 2023, there were over 1,800 applicants, and 60% of those applicants were pardoned and had their voting rights restored. Again, that is compared to an average of 7 to 8 in Mississippi per year. In Virginia, an individual is eligible to apply to have their voting rights restored by the governor if they were convicted of a felony and are no longer incarcerated. The current process in Virginia requires an individual to apply through the Secretary of the Commonwealth for review and then action by the governor. In Virginia, current Republican Governor Glenn Youngkin has pardoned and restored the rights of over 4,000 individuals since taking office in 2022. Tennessee, another state that restores the right to vote through application, has a process in which voting depends on the type of crime, as in Mississippi, that an individual has been convicted of. And they may have their rights restored upon completion of their sentence and a period of supervision. They must receive a pardon by the governor or have their full rights of citizenship restored by petition to the circuit court that has jurisdiction over them before they can submit the certificate for their restoration. In Tennessee, since taking office in 2019, Governor Lee has issued several dozen pardons at the end of the year on 3 occasions from 2021 until 2023. This brings us then to Mississippi and the voting rights restoration process here. And one place to start, as the chairman noted earlier, as has been found by the speakers poll as well, Secure Democracy Foundation, we commissioned a poll through ARC Insights last fall on issues relevant to voting rights restoration. And we found out of a sample of 600 likely voters that 8 in 10 voters support restoring voting eligibility to Mississippians with a past felony conviction who are no longer incarcerated and are living, working, and paying their taxes in a community. A clear process to assist individuals to regain their voting rights is popular. The Mississippi Constitution lists 10 general crimes, and as the representative mentioned earlier, the crimes that are disenfranchising include, of course, murder and rape, but also bribery, theft, arson, obtaining money or goods under false pretense, perjury, forgery, embezzlement, and bigamy. In Mississippi, as mentioned earlier, the population of 1 in 10 with a felony conviction, but presently 52,000 approximate individuals are the total number of Mississippians who are disenfranchised for nonviolent crimes. That number is 69,000, including when you include the people convicted of violent crimes. So again, the vast majority currently disenfranchised are for nonviolent offenses. That number of individuals disenfranchised through nonviolent convictions is roughly 2% of Mississippi's current voting age population. Some of the things that we would offer for consideration that I'll have more information about in a moment, as the committee considers and the legislature considers the criteria for restoration, the type of restoration process, whether to have an automatic process as 46 states do, or by application as 4 states do. We'll talk a bit about the education, the public education involved in other states around the policies that are in place, about the statutory process, and about the constitutional process. The 3 categories that, again, to just go back to the maps, out of our other states, there are 24 states which restore voting rights following incarceration. There are then 15 states that restore voting rights following the completion of parole or probation. And there are 9 states that restore voting rights after the fulfillment of financial obligation. And that's how you get to the numbers I presented earlier. Now, in the automatic restoration process, a few of the descriptions for what this experience looks like in other states. Obviously, this is a simplified process for the election administrators and the state to oversee. It does not require the state to establish the oversight process or delegate authority to a second entity. In the application process, that provides the legislature, of course, with greater oversight of the process, having to take individualized action. And it's a slower process for greater government involvement and deliberation. One thing, and this is related to a couple of the handouts that you have from other states that we would request the committee consider, is that the process currently for restoration in Mississippi should have greater transparency and public education about just what simply the current status of the law is. So we would urge consideration of having publicly posted on the Secretary of State's website or hosted by the legislature on its website the process for individuals that's currently rather inaccessible to obtain that information. the second point we would make is for election officials to have the clear instructions through that transparent, publicly available information on the process to ensure proper registration of individuals that may be eligible. And then finally, we would just encourage, as the work of today, the efforts of this committee today with this hearing is a great example of doing public education that's required, should there be any bill passed regarding rights restoration. Now, to talk about the potential pathways for restoration. One, through statutory amendment, would be provided by simple legislative action. However, as I'm sure the members are aware, the Constitution of Mississippi does limit the power of statutes when it comes to rights restoration. So the statute can provide for the framework to develop restoration, the criteria, the timeline, et cetera. However, in section 241 and 253 of the Mississippi Constitution, there is delineated the current disenfranchising crimes in part, and then the process for restoration. And so one or both of those sections of the Constitution may be needed to be amended in order for a new path for restoration to be created. There's the reason why we say may here, I'll get to later, but I just want to note now, it is possible to provide for a blanket suffrage bill treating each individual convicted of certain crimes through the same process that people currently go through in the suffrage bills that people are named as individuals. That's just something for legislators to consider, again, for further conversation perhaps. But through the statutory method, of course, one option, as previous sessions, House Bill 1609 did, would be to provide those explicit restoration methods and amending the list of nonviolent disenfranchising crimes. And ultimately, we would just note that any amendment that happens outside of changes to the Constitution could face legal challenge. And so would just urge that that is one part of the consideration of the potential pathways going forward. However, as I mentioned briefly just before, a suffrage bill may be able to restore suffrage for individuals when certain criteria are met. This is because in section 253 of the Mississippi Constitution, those criteria are delineated, and a vote on this bill would require 2/3 of both houses of the legislature to meet those criteria per our analysis. So what can be done now? One consideration would be to provide an explicit list of disenfranchising crimes online. That requires no further legislative action. And that's why you have a handout from the state of Tennessee and another of just what this can look like in other states. That can allow for the clarifying of the current restoration process. And again, we would say this could be either through the Secretary of State's website hosting it or the legislator's own website hosting it. And we asked about this when talking to likely voters in Mississippi last year, and the support was overwhelming. So 75% of likely voters supported the state publishing on a government website the list of how many citizens with a past felony conviction can take steps to have their voting eligibility restored. Something else that can be done now, again, with action by members of this committee and others, would be to establish a process for notifying eligible residents when they can apply to have their rights restored. And this was something we asked likely voters about last year as well. And again, here the support was overwhelming. So you'll see more than 3/4, 77% of likely voters supported the state's notifying citizens with a past felony conviction if they are eligible to have their voting rights restored. Finally, on this topic, we would say that there's a need to provide and support the courts in recording and sharing information regarding sentencing. I want to give a lot of credit to the previous presenters from Empower who have done good work on this in the past. The current state of the data collection and sharing is really poses a lot of challenges for tracking accurately what's going on, who knows what about which individuals. And we would urge this committee to consider, along with other parts of the legislature, what could be done to improve that data so that we have accurate information on who's been disenfranchised for which crimes and the status of their sentencing, including parole and probation and their financial obligations. Finally, I just want to mention that there's a tremendous opportunity here, I think, thanks to the hard work of Chairman Wallace and the members of this committee, to have Mississippi take a look at other examples from other states and improve the process for individuals who've been convicted of nonviolent crimes in restoring their right to vote. And I want to thank the committee for your diligent work on this topic and for having us here today. Thank you, Mr. Chairman.
Thank you, Evan. I noticed that one question I have and like some of the states, they don't require the restitution. I mean, it is why are they, allowing them to the monies that they owe either to the court or to the victims, sometimes it's restituted. Some states choose to just let them not pay the fees and restore their rights, or.
Yes, Mr. Chairman, members of the committee, that is correct. In some states, payment of restitution is not a necessary condition for regaining the right to vote. And if I think I understand the question at the heart of what you're getting at there, I believe the calculation among some of those states would be the impact on recidivism, as Empower spoke to earlier. Some of those states have made the calculation that having that as a criteria is not necessary, and they desire to have the restoration happen earlier in the process of someone who still faces restitution out of an interest for addressing recidivism rates in their state.
Any question from the committee? Gentleman from DeSoto.
Thank you, Mr. Chairman. Thanks for being here and presenting to us today. I had a couple of questions. The first one is, you guys listed, you were talking about general crimes and disenfranchising crimes, and you said it includes 70 nonviolent disenfranchising crimes. Is there any way you could provide this committee with a list of what you consider the 70 nonviolent? And then the second thing was, you were talking on the next slide over, it was there's 69,000 individuals in our state that are disenfranchised either through violent or nonviolent crimes. What percentage of that 69,000 did you say were nonviolent?
Mr. Chairman, yes, 52,000 are nonviolent.
52,000. Okay, thank you.
Lady from Hines.
Thank you, Mr. Chairman. I have a couple of questions. I've had a bill for the past couple of years to spell out the process of suffrage through the legislature. And the issue with suffrage, well, there are a lot of issues with suffrage here, but one of the issues with suffrage is that the criteria is based on whatever the philosophy or personality is of the leadership. For example, embezzlement is a crime that, at least on the House side, is not taken as a crime that should be should allow a person to be restored. Whether or not you have a good relationship with the chairman determines if your suffrage request will be considered. So my question is, should this body be stringent on what that criteria is and be consistent with how that process should go, so that any one of these 69,000 or 52,000 Mississippians understand what they're up against, what's required when they're asking for suffrage? That's my first question.
Mr. Chairman, thank you for that question. We would say for our part at Secure Democracy USA that I'm glad that you asked about the criteria. One thing that I didn't mention earlier that I think has bearing on this is a good deal of the elaboration of which crimes are disenfranchising and the judgment exercised about that comes from an attorney general opinions over years in fleshing that out and defining that. And so to get to your point about, who is deciding and when, it has been a, murky process and is somewhat unclear from those actions. And I think there's an opportunity for the legislature in clarifying that for transparency, and the work of this committee, I think in the previous year was a great stride in that effort of having transparent, clear, and straightforward rules that any citizen in Mississippi can know and then comply with. So that would be how I would consider that question for our part.
I appreciate that. And I appreciate you lifting up the fact that it's, that this list is a bit misleading because there are iterations of these crimes on this list that disenfranchise you. Voter fraud is another crime that's not on this list, and it's not publicly provided on any site where a person would know what those crimes are. In addition to these crimes, one of the things that on the House side that we attempted to do that I didn't like was adding more crimes to the disenfranchising list on House Bill 1609. What are your thoughts about increasing this list with the legislature adding more crimes?
Mr. Chairman, member, respectfully, we have no position on the types of crimes and would leave that to other organizations. Yeah.
Okay, last question, Mr. Chairman. We've stated over and over again how difficult the suffrage process is. You have to go through the subcommittee process, the committee process, then the full House on both sides, 2/3 votes for those bills to pass. As you stated in your PowerPoint, only 207 people have been restored via suffrage since 1997. Knowing that this process is so difficult, we also had at least 4 bills that were vetoed by the governor, given all the work that we had done this past session for suffrage. What's your position on the governor being able to veto suffrage bills, particularly when there's no explanation given as to why he vetoed those bills? Do you see that playing out in other states? I know there's some states that you stated that the governor has full power to restore people, so I'm just wondering what your position is on that. Thank you, Mr. Chairman.
Mr. Chairman, Representative, thank you for the question. I would put, to put in context the actions in Mississippi, a number of the other, there are only 4 states that require voting rights restoration by application. And in all of those other 4 states, there is a higher rate of review and of granting of those rights to be restored. So to put in context any of those actions there, it is the case that Mississippi would be an outlier in terms of the pace and category of consideration for restoration by even among states that have individualized applications required of people.
Yep, gentleman from Lowndes.
Thank you, Mr. Chair. Thank you for your presentation today. I have a few questions. I want to go back. I guess I'll start with one of your slide presentations. You talked about legislation possibly being challenged in the courts. I think because of the Constitution and how it sets up, can you kind of expound on that a little bit? It was one of your slides that dealt with, I don't know which one it was, but it could, if we don't do it right, it could be challenged in court, because of not amending the Constitution. I just want you to expound on that a little bit.
Mr. Chairman, Representative, thank you for that question. Yes, and here, I would want to frame what we presented as, we endeavor to give expert analysis and policy review to legislators like yourselves. And where there's any degree of uncertainty, we want to name that. And this is one area where we felt it is possible to pursue the type of path of a either blanket suffrage bill or statutory changes. However, our analysis and understanding, thanks to some of the other experts as well in the room here who have done years of work on this topic, is that there is a constitutional question that's implicated based off of Section 241 and 243. But there may be a path within Section 243, Section 253, pardon me, in which you could approach the issue through blanket suffrage. So we just wanted to name that I think is an open question that reasonable analysts could make different conclusions about, but would be worth, I think, further consideration with Legislative Council.
Thank you. My second question is, and look, it might seem trivial, but when did the practice start of taking voting rights from individual for crimes that are not related to the crime that they committed or have been charged or convicted of? When did that practice start? I know where we are, but when did that start through your research?
Mr. Chairman, Representative, well, thank you for that question. As someone trained as a historian, I appreciate the grounding in that for consideration by legislators. This practice and policy dates back in Mississippi, at least to the 1890s, for some of the explicit lists of what disenfranchises individuals. However, the practice existed before that in our republic. So you're looking at an over 200-year history by one stretch or another in which there were policies for disenfranchisement.
And my final question, I was looking at the list of crimes, and I don't know if you can answer it, or maybe it's a question for the presenter from the Secretary of State's office. But we have 10 crimes that are in our Constitution. Well, these crimes here have been expanded, but they've never been codified by the legislature. But they're disenfranchising crimes that people are going to prison for. How is that possible? And does the Attorney General have the wherewithal to just arbitrarily add crimes such as what took place within the last 10 years, adding 12 more crimes to the disenfranchising crimes that are included in our Constitution?
Mr. Chairman, Representative, yes, you're right that the elaboration of that list and the interpretation of the statutory language and constitutional language has been a matter before both the Attorney General and therefore the courts. And that is part of why I caution and say it's somewhat uncertain, the status of that, because that is made through those decisions within the executive branch and then any litigation over it in the court system. So it's somewhat uncertain, the path that took and any path forward for that opinion.
So we do agree that this has not been codified through the legislature, and you're saying that it's unclear whether or not the authority was there to expand.
Yes, sir.
Thank you.
Any other questions? Evan, we appreciate you coming today and your presentation, and thank you for all you do. Thank you.
Thank you, Chair.
Appreciate you.
Moving right along, folks. We're gonna bring up a former colleague of ours, Nick Bain. I know Nick has worked on this, and he's helped us, this past session, try to get 1609 passed, which it did pass in the House. We just fumbled at the other end of the chambers. And so, but anyhow, Nick, we appreciate you coming down today. So go ahead.
All right, thank you, Mr. Chairman. Ladies, gentlemen of the committee, it's always good to come home, so thank you for having me. As you know, this is something we worked on when I was chairman of Judiciary B. We passed a number of expungements. So what I wanted to kind of do is just talk y'all through the process or really the evolution of our statute, because when I first got here, it was a very narrow statute, expungements. There was only a very few things you could expunge. And then in 2015, 14, around that, when we did the big criminal justice 585, this was all a part of it. We kind of expanded that under the now Commission of Agriculture, and we added and kind of expanded the expungement statute to what we have now. The general expungement statute that is used by most practitioners like myself is 1977, I believe, or 71, one of the two. In any event, doesn't matter. And the reason you get confused on that, I'll touch on that, is there's half a dozen ways to expunge something. But be that as it may, so now we kind of, under that statute, there's a whole lot of stuff now that can be expunged that at one time couldn't be expunged. And when I became chairman in 20, we began looking at things like you're doing and in other ways to try to expand it even further. Under the current statute, and as a practitioner, I've expunged probably at one time as many as 5 felonies. Under the current statute, there's language in there that says anything that relates from the same transaction and occurrence. And that can be whether it was multiple drug cases that happened on the same day or something like that. The problem and the concerns that happens are those when you have a situation like came into my office, a girl from Tishomingo County who had never been in any trouble before, suffered from some mental health issues, but in the long story short, she committed possession of meth charge, maybe like in July, caught a charge, and then in August caught a charge, and then in maybe September caught a charge, back to back. The issue with that is she cannot get an expungement, except for one. So she still has a felony. In other words, it doesn't do her any good to get one. So in 2020, we started looking at ways to allow people in her situation to get one. Because candidly, she came to me and I said, you know, I can get you one, but that's it. And she said, well, I can't work. I said, I have a job right now ready to pay me $25 an hour. And I said, I'm sorry. That's what the law is. I can't give you that. So we passed that bill. We passed that in 2020, overwhelmingly in the House and in the Senate. Both sides passed it. It went to the governor. It was vetoed. And we came back with it. He gave us a veto message, came back with it. Basically, the message said it was just too broad. But we came back with it. We passed it again. The House passed it in 21. It was Representative Owen's bill. And in that situation, we put some restrictions on it that allowed it to be after a certain amount of time, like 15 years or something like that. Currently, you get expungement after what's been mentioned, after 5 years after being off of paper or probation or something like that. This would allow not only for that step, but also to go with these to have multiples, but after a longer period of time. That passed the House overwhelmingly, and it did not pass the Senate. We did not bring that back in 22. In 22, we tried a couple of things. The lady from Hines had a fantastic bill, which is something that I think y'all should bring back, which is, like I alluded to, there's half a dozen ways to get expungements in Mississippi. She had a bill that basically streamlined that. It made it easier for practitioners, made it easier for courts and judges to look at. For example, you get expungement through 99-15-26, which is kind of a non-adjudication statute, which that is Mississippi's version, in my view, of an automatic expungement. You go through that, your guilty pleas kind of put on the shelf. It's not accepted, and if you finish the program, you can come back and get an expungement. You have other expungement avenues such as drug court, intervention courts, pretrial diversions, and some of those things, and of course, under our general statute. I think that bill has merit. It's something that we passed, and I don't know that the Senate passed that one. We came back also in 22 and passed a bill, which I thought was, what as chairman that I heard from a lot of people, from circuit clerks and a lot of election people, was tell us what to do. Because here's the issue we have with expungements. Yes, we can expunge your felony, but what does that do to your voters' situation? Circuit clerks had no idea. They said, well, sometimes we let them register, sometimes we don't. As a lawyer, and how I've always been trained, when you get something expunged, it restores you to the way you were before it happened, which in my view and my reading of that would mean you should be back, have your suffrage rights returned. We passed a bill that basically said that if your record has been expunged, if you've gone through the process of hiring a lawyer, giving notice to the DA, giving notice to law enforcement, taking that to court, and the judge approving it, then you should be able to take that order from the court, take that to circuit clerk, and allow your voters' rights to be extended or returned. That bill was also vetoed by the governor. I think that's an easy fix. His message on that basically was we circumvented the Constitution in doing it that way. I disagree with that and always will, but be that as it may, we did not come back with that in 23. So those were the primary things. That's kind of the evolution of the expungement and voting since I've been here. Something that I would ask y'all to consider, there's some tiers to expungements and the situation that we're in. For example, let me tell you about a guy that came to see me. He got a possession of marijuana back in the late 80s. All right, we all agree, the last time I probably defended somebody charged with marijuana has been 5, 6 years ago. You just don't see it anymore. But this guy back in the late 80s, as you can imagine, marijuana had a different stigma than it does now. So he caught a felony for it. And he is a convicted felon to this day. He asked me, came in and wanted me to expunge his record. I said, okay, I can do that. That's easy. Except for this, there are no records of it. When somebody, gentleman from DeSoto, for your question, when somebody comes and hires me to do a petition for expungement, they come in, I take everything down, file the petition. On that petition, I attach a copy of their sentencing order, discharge from probation, whatever the case may be. But if those don't exist, I can't do that. So, for example, this guy in the 1980s, before they put all this stuff and digitized it, it's a physical copy. And we don't have that. So he is, by virtue of losing that, by virtue of not having that, he cannot get his record expunged. Because what happens is once it gets expunged, you have to take that sentencing order, the date they were arrested, the date they were sentenced, all that has to be shipped off to the FBI to clear up their record. If I don't have those dates, I can't do that. So when you talk about an automatic expungement or something like that, I would submit to you that a way to do that is for people like him. Those type of crimes that are over a certain age. Now you still run into the situation with how do you clear that up? I think that could be done with some language and with working with the Department of Public Safety to do that. But those type of guys have now created what I call a tiered system, because you have this expungement, like I said, has really only taken off in the last decade or so. The other way you expunge has been youth court, drug courts and intervention courts. Those really only started about 20 years ago. So everything prior to that, it's really difficult to expunge their record. So you have a lot of people out here who have expungible cases, but we can't do it. And you have people who have now gone into drug court which if you finish that drug court, it is an automatic expungement. If you finish a pretrial diversion, it is an automatic expungement. And then, of course, now with the new expungement law, people have the ability to get expunged. People before those became laws are really out of luck. And so so my heart goes out to those, and I would ask you to look into some of those older felonies, that there may be a way to get that done. The issue with, I heard Christina Dent talk about this, Grant Callen talk about this, about 1 in 10 Mississippians. I submit to you, I've seen that number higher because you're seeing 1 in 10 that have a felony conviction. But there's approximately 100,000 Mississippians that are in drug courts, pretrial diversion, and non-adjudicated. So you're talking about roughly 350,000 Mississippians that have some type of prosecution, probation, or they're in some type of system. All right, now those 100,000, if they finish up their programs, they're going to get an automatic expungement. The rest of them have to come to me to get them expunged, and that's where the problem lies in what I told you about. It does become a process. Like I said, we tried to clear that up with the expungements and getting them some type of restoration of their rights. And I've heard y'all talk about the restoration and the disenfranchisements. You know, the biggest issue I always had as chairman in that sense was it never made sense to me. And I always wanted to try to have fairness for everybody. It never made sense to me that somebody charged or convicted of child pornography could vote, but somebody who writes a bad check cannot. And I think that's incumbent upon y'all to fix that. And it's something we had a bill to fix that, but once again, it didn't make it all the way through to the other side. Mr. Chairman, I appreciate you picking up the mantle on these issues. As I told the lady from Hines, I don't think this started being discussed among these two bodies until really 2011 and 12. So I appreciate you pushing up the mantle. For me, it was always a workforce issue, but first it was always a human issue. And it's something that there are people out here, the people you represent, the people we live with, the people that are paying taxes, who are struggling with this. The lady I told you who had a $25 an hour job, she's now on disability. She's being paid for by us, simply because she couldn't get a record expunged. Okay. To me, it's a workforce issue. It's removing those barriers for people being successful. And again, I appreciate you picking up the mantle. I'll answer any questions, whatever I need to do.
Lady from Hines.
Will the gentleman yield?
I have horror stories about you saying that.
I'll be nice today. I asked you this earlier, and so I know you don't have the answer, but I'm going to ask you again out loud because I know the guys from the Secretary of State's office are sitting right there, and if they hear this, maybe they can go and search up an answer real quick before they get to the table. I know that out of habit, we always refer to disenfranchising felonies, but I've looked in the Constitution and I've looked in our statutes, and I don't see any reference to a disenfranchising crime having to actually be a felony. And I see some of the disenfranchising crimes that are listed in the Constitution actually being misdemeanors within our statutory code. Are you aware of anywhere that spells out the felony portion that we've all come to?
No, I think we're all relying on an Attorney General opinion on that, if I'm not mistaken. But there is no statutory provisions on that. Maybe some case law, but for the most part, I think you're absolutely right. There is no definitive list out there.
Are we concerned possibly that we have people who aren't being allowed to vote because they have a disenfranchising misdemeanor?
I've
Because
never
of this?
heard of anybody, but again, I think it's certainly a possibility, and I think if somebody wanted to push the issue, there certainly could be a legal argument under a plain reading of the Constitution.
The other thing, I just wanted to follow up, the bill that you were talking about where we attempted to sort of just clarify the expungement statutes. While there is one main expungement statutes, the expungement laws, I would say, are probably spread out among 20-ish statutes, and they're not even all like in
No,
sequential order.
They're not.
And
So-
so when we presented that bill on the floor, the questions that I got were, well, what are we changing? And people had a hard time understanding that we weren't actually changing any of the law. We were just trying to put it all in one spot so that it would make sense. And then we got questions along the lines, well, is this a lawyer bill? And it's actually the opposite of that, right? Because it would make the process more simplistic, and then people could actually potentially get themselves expunged. It wouldn't be such a convoluted process, correct?
Well, now you're meddling, but, yes, you're right.
Okay.
It absolutely could be a situation to where it simplifies the process. I mean, I'll say this, it's more simpler now than it's been. Before, you had, I think gentleman from DeSoto alluded to this, you had a statute that you could pretty much expunge anything if it happened when you were under the age of 26. We did away with that and put it under this old, with the age requirement. We had a number of statutes that allowed you to expunge anything that happened within a municipal court, or then specific misdemeanors that happened within a justice court, but it didn't happen within a municipal court. So we cleared up all that. This is your bill, just simply tried to clear it up and make it a streamlined issue for really the private citizen.
And then the last thing I'll touch on, and we've talked about this, not just you and I, but this has been discussed on the floor. Generally speaking, is it easier to have your right to own a gun restored than it is to have your right to vote restored?
100%. You can, the process to do that is really pretty much like, it varies from, I guess, district to district. In my district, we file a petition. It's called a petition for rehabilitation, certificate of rehabilitation. It gives you your gun rights back. My judges require basically the local law enforcement to sign off on that. That's not required in the statute, so that varies. But for the most part, yes, that's how you can get your gun rights back, as opposed to a suffrage where you have to come down here and debate the bill and know your senator or your representative to do that.
Thank you.
Gentleman from DeSoto.
Thank you, Mr. Chairman. Nick, it's good to see you. Question for you, and this is maybe a little bit, I don't know if it's off topic, but since we're discussing it, and you brought it up, the gentleman that you referred to that had a 80s felony marijuana charge, and you have no way to expunge him because we don't have records?
I don't have, I can get him an order to expunge it, but I don't know that it would work when I submit that to the FBI, because we don't have a record of when he was arrested, which we would expunge. We don't have a record of the sentencing order, because it was, like all, I guess, counties around Mississippi, they've now kind of digitized, and at a certain point, those records just become obsolete and they discard them or whatever the case may be.
So is there, I mean, that may be a separate issue that needs to be addressed by the body, because it doesn't seem right that there's no process, at least for, I mean.
Not that I'm aware of. I haven't come across one, but you're exactly right. And that's what I'm saying. I mean, you're almost getting into somewhat of an equal protection issue with him as versus to the other ones. You have issues regarding, he can't get it expunged when somebody in a like-minded situation could get it expunged. So, how do you remedy that? There was mentions about creating a database, potentially doing that. That's something that you guys would have to discuss. It would be costly to do that.
Okay, I just,
In my view,
that
it'd be
doesn't seem
costly.
right that, we
No,
don't
it's
have
100%
records
not right.
and that there's
Um,
not some kind of path forward for somebody, regardless whether it's expungement or whatever, that,
I could get his gun rights back, but I couldn't expunge his record.
okay, thanks.
Anybody else? All right, gentlemen, but thank you for being here today. Appreciate you coming down for us. All right, we're gonna move right along. We got representatives from Secretary of State's office. Thanks for being here. And I know this has been brought up and, you know, as we've talked before, this disenfranchising crime list. I personally feel there's some crimes on this list that need to come off. And then I feel personally, there is some crimes, and I looked at, this copy from Alabama, but anyhow, there's some crimes that need to be on the disenfranchising list. So Kyle, what's Secretary of State's opinion?
Thank you, Mr. Chairman. So before I kind of get into what we have looked at the list of disenfranchising crimes, I kind of wanted to do an overview of where we're at in Mississippi with disenfranchising crimes, which ones are constitutional, which ones are from Attorney General's opinions, and kind of how we've gotten to the state of where we are. And how that system works in the Secretary of State's office, how that information is transmitted to circuit clerks, and how that process actually works of someone being taken off for disenfranchising crime. So currently, we do have 23 disenfranchising crimes in Mississippi. They are through Section 241 of the Mississippi Constitution, various Attorney General's opinions, and Mississippi Code 23-15-151, which is when the legislature added voter fraud to that list. So those crimes are arson, armed robbery, bigamy, bribery, embezzlement, extortion, felony bad check, felony shoplifting, forgery, larceny, murder, obtaining money or goods under false pretense, perjury, rape, receiving stolen property, robbery, theft, timber larceny, unlawful taking of motor vehicles, statutory rape, carjacking, larceny under lease or rental agreement, and voter fraud. And to address some of the questions that have come up about some of the Attorney General opinions or even the felony, as for the felony, I was trying to, as you gave me the heads up, I was trying to find the citation to the case. I believe there's a consent decree that distinguished between a felony and a misdemeanor being disenfranchising. Previous to that court order, there had been some Attorney General opinions, to your point, that there was not a distinction in the Constitution. So a felony was it doesn't matter if it was a felony or a misdemeanor. That stopped about 1989. I believe the case was Cotton v. Fordyce. I can get a little bit more information for you on that, but there was a distinction made to separate felony from misdemeanor. And that's where we've now gotten to the felony, shoplifting, felony. And the Attorney General has upon these, of course, I could always refer to them. They can speak to their opinions much better than I could, but I've obviously read quite a few of these in my position as Assistant Secretary of State for Elections. And they have looked at the crimes listed in the Constitution and found the common law elements that were for these crimes. And if a law that the legislature passed had those same elements, then viewed that as disenfranchising in those opinions that we've gotten. That is why we have seen both robberies are on there, but for an example, and this is one because I've recently read this, like sexual assault is not considered because it doesn't have the same elements of rape under the Constitution. So the Attorney General found that was not a disenfranchising crime because it did not have the same elements for criminal purposes. So once someone is convicted of these crimes, the information is entered into at the clerk level what we call the Administrative Office of Courts, or what I call shorthand AOC. Once it is in their database, they have a list of felonies that meet the elements, and based on these Attorney General's opinions and the Constitution, that they will send to the Secretary of State's office. That is directly tied in with the statewide election management system. And we will use matching criteria such as first, last name, date of birth, social security number to identify that. With a voter, if someone tries to register to vote for the first time, or if someone is a registered voter, it will alert the circuit clerks and election commissioners automatically that that person may need to be taken off the voter rolls. So at this time, there are approximately 90,000 entries in the AOC database that we have, meaning 90,000 entries for a disenfranchising crime. That can be repeat offenders. So in preparing for today, I've tried to control for the number of unique people, meaning maybe not repeat offenders or someone who had multiple disenfranchising felonies in a single conviction. And there are roughly 57,400 unique entries in the AOC database, meaning unique individuals, and not one person having 4 or 5 disenfranchising crimes listed in the system. And this, also, I looked at the number of voters who were purged due to disenfranchising crimes, meaning they were registered and then were convicted. Roughly 14,766, as I checked this morning, and roughly approximately 1,000 people who were rejected, meaning they were not registered voters. They were convicted of a disenfranchising crime, tried to register to vote, and were rejected because the system flagged them as having a disenfranchising crime after reaching out to the AOC database. Before I obviously launch into the Secretary's view, Mr. Chairman, I want to be very clear that this position, the current constitutional law has been repeatedly upheld. And so anything that we're talking about here today from the Secretary of State's office is not on the legality of the system. Once again, it's been upheld in the Fifth Circuit several times. It's more or less on the policy of where the state should go from here. So nothing should be taken as to indicating whether or not the current system has any issues with the legality of it. Mr. Chairman, looking at the questions you presented to us about, first off, what crimes should be added or what should be altered, we tried to look through this through a conservative lens and looking through the aspect of a person who is being convicted of a disenfranchising crime at some point goes through all three levels of government. And when I say they're going through all three levels of government, they are being brought forward on a crime that is put forth by this body, by the Mississippi legislature. The Mississippi legislature has passed a law saying this is a crime. There will be so many years up to a maximum of sentence that they will be punished for, with possibility of parole or no parole, depending on what this body has said. Then they will go in front of a jury or their peers and a judge who will listen to the particularities of their case, specific facts, and make a determination. And of course, you have the executive branch and the attorney general or district attorney bringing the weight of the state against that. And of course, at the Secretary of State's office, we are always very cognizant of the fact that there's nothing more important in a democracy than the right to vote. In a representative democracy, that there's nothing more fundamental than having your voice heard and having a say in your government. And so we tried to look at this through a conservative lens in preparing this. So what we have looked at, and in trying to create a bright line and maybe even looking at if there should be a list and differentiating between felonies, we feel that it should actually be all felonies. That if you violate a law of the state and you break that social contract, then you should not retain the right to vote while you are serving that sentence. However, after that sentence, you should be able to, if you're a nonviolent offender, be able to go through a process and have your right restored. And have violent crimes, which is a set of laws that the Mississippi legislature has already identified as violent, and some of the criminal statutes has already set aside which ones are violent and which ones are nonviolent. If you are a violent offender, you can go through the same process now of having your rights restored by a pardon of the governor or a 2/3 vote by both bodies, sides of this house. And we came to that conclusion and going through the list of non-disenfranchising crimes. I looked at a list of these, and I do have a handout. I apologize, I was not able to get enough. We've been quite busy with the election, so I was not able to get quite a few printed. But there is a very good list prepared by the Administrative Office of Courts that delineates all the felonies, all the criminal statutes in Mississippi. It lists out by the statute number, the title of the crime, and it will actually highlight whether it is sent to the SOS or not. So it has a column, send to SOS, meaning send to our office to the AOC database. And in those, some of the crimes that are non-disenfranchising that I would like to list off are child exploitation, making a terroristic threat, intimidating a witness, witness tampering, child abuse, touching a child for lustful purpose, identity theft, sexual battery, domestic violence, kidnapping, human trafficking, buying or selling of an unborn child, drive-by shooting or bombing, aircraft piracy, or unlawful use or placement of an explosive. All of these are non-disenfranchising under the current Mississippi Constitution and Attorney General opinions regarding as such. And a use of a felony as a bar is in line with other provisions of the Constitution. Grant earlier from Empower talked about how not being a qualified elector could bar you from running for office, and that is a qualification of office. There's actually a separate provision, though, that independent of being a qualified elector prevents someone from running for office, and that is Section 44 of the Mississippi Constitution. Section 44 of the Mississippi Constitution prohibits anybody from running for office if they were convicted of an infamous crime. And an infamous crime is a felony. So there are already provisions in Mississippi law that use felony as a baseline for whether you can continue to do certain activities under law. And so we think that will be a better right line rule than trying to differentiate which crimes may be worse or best, particularly in the fact that the Mississippi legislature has already set out certain penalties for certain crimes. So if the Mississippi legislature feels that a crime should only have 2 years worth of penalty, they can set that in statute, and a judge will set that order. And then once that person has completed their sentence, any probation or parole, and paid their fines, they will be able to become a registered voter based on the law set forth by the Mississippi legislature. And in getting to the restoration of rights process. And we think this is very important that these two are tied together, and that there should not be an expansion of the list, especially to all felonies, without a clear process for people to have their rights restored back. We certainly do not want to see more people become disenfranchised with no clear process on having their rights restored. And so we view this in a tiered process, that if you are a nonviolent offender, once you have finished your prison sentence, any parole if we're only early release, a probation if that was set forth, and then paid any restitution or fines, then you could get your rights restored back. And in addressing some of the conversations that were on automatic versus an application process, what we think would really need to be considered is the state of data that the Secretary of State's office and being able to provide to circuit clerks and election commissioners, how we would receive that. What we would need is clean and clear records and a set of data that we could use to match against our own voters, which would need first, last name, date of birth, and last four social security number. And to have that be able to cleanly match against another system. I think probably the Mississippi Department of Corrections would probably be able to provide a little bit more information on that, as they already have information on parolees, inmates, probationers, on what their database looks like. If we cannot get a mechanism in which we could cleanly be able to identify which people who have finished and completed their sentence and all parole, probation, and fines, then the option would be to have someone present their documents either to the Secretary of State's office or the circuit clerk's office to be taken off of that AOC database, such as providing a certificate of discharge and completion of probation or parole. And then we could remove them from the database to allow them to vote and go forward. So to recap, we do believe that having all felonies would be the cleanest and best approach, would have addressed some of the concerns that you espoused, Mr. Chairman, of having many crimes that some may view as particularly more heinous being allowed to vote, while some that are not so much still losing that right. It also has other further bases in the Mississippi Constitution in Section 44, and to allow a clear process for nonviolent offenders to have their rights restored while still making violent offenders go through a more rigorous process.
Yep, lady from Hines.
Thank you. Do you envision specifically with the restoration of rights process, the Constitution needing to be amended? That concerns me, that we won't actually be able to just do that via statute.
Yes, ma'am. So I've taken a look at that. There have been provisions in the past. Now, I don't know if they were challenged, so they may have not been put forth to a constitutional provision. So I would say, to the fact of adding a crime, the legislature has the authority to add a crime and qualification. They've done that through voter fraud, and they can add any qualifications they want to a voter. To the restoration of rights process, there was a bill passed, I believe in 1947, I may be a little off on the year, that added a blanket restoration of suffrage process. And this is still on the books for World War II veterans and World War II veterans who were honorably discharged from service. They were able to bring their honorable discharge papers to the circuit clerk's office and have their rights restored. So that is something that the Mississippi legislature has done in the past. It is still a law. When I looked a couple months ago, it was still on the books. I don't know if that was ever challenged, so I don't know if the constitutionally that was ever addressed, but I believe that was passed by a 2/3 House vote under 253, and veterans of World War II and World War I were allowed to have their rights restored by bringing their honorable discharge papers to the clerk's office.
Another question I have is, he's gone, I think, Representative Bain, former Representative Bain, mentioned some of these older crimes and a lack of paperwork and things like that with respect to trying to get these expunged. Does the AOC database that you talked about have any of this information that would be useful for those older ones?
So what we get from the AOC database is we don't get any kind of recordings or anything. We get their name, certain key identifying information, and the criminal code in which they were convicted of. So we don't have any documents that we can see from our side and what may be in there. AOC does go back to, I believe, 91 or 92. So even some of the older crimes that former Representative Bain was referencing, I don't know would even appear in the AOC database, because I believe it goes back to the early 90s, 91, 92.
And I know you said that they don't send it to you, but do you know what they maintain as far as actual documentation?
Unfortunately, I do not.
Okay, thank you.
Any other questions? Well, sir, we appreciate you coming, and we look forward to working with the Secretary of State on this. Thank you very much. That's it for today, folks. I thank everybody for being here. Thank the committee members. Thank y'all for what y'all do. Dismiss.
I was like, they get done before 3:30. 3:30 is my problem. I do have respect for it, but I don't really. I don't think I can. Good to see you. I always think about quick.